Hello everyone. Yes, so there was a slight glitch in the previous session, so here I am. So let's continue with what do we mean by interpretation of statutes. Now, please remember, interpretation of statutes will arise when the people who are giving decisions on this or who are following a particular law, deed, or documents, they will want to know how to follow that and what are the legal steps and provisions and how to interpret them. Because please remember, anything is open to interpretation differently by different people. So obviously there are certain set of rules which allow you to interpret things in a certain way. All right. So let's move on with interpretation of statutes. Just give me a second. Okay. The study relates to interpretation of statutes, deeds, and documents. So first of all, we must understand what these terms and some other terms denote. It would therefore be important for us at this stage itself to understand the term statute, document, instrument, deed, and interpretation. Statute. To the common man, the term statute generally means the laws and regulations of every sort without considering from which source they emanate. Okay, so for a common man, statute means a law. So obviously, law needs to be interpreted. At the end of it, it is a language, right? And language is open to interpretation by different people. So what we'll discuss in interpretation of statutes is how do the various statutes be interpreted. However, the term statute has been defined as the written will of the legislature solemnly expressed according to the forms necessary to constitute. It is the law of state. Normally, the term denotes an act enacted by the legislative assembly, legislative authority, example, Parliament of India. Okay, so this is just a brief introduction about what you mean by the term statute. I explained it to you. Please take a minute to go through this. Any questions? Please ask. Any questions you may have, please ask me. You want to take another minute? Any questions, please ask me. Okay, then let's look at the Constitution does not use the term statutes, though one finds the term law used at many places. The term law is defined as including an ordinance, order, bylaw, rule, regulation, notification, and the like. So the term law is defined as including any ordinance, order, bylaw, rule, regulation, notification, and the like. In short, statute signifies a written law in contradiction to unwritten law. Okay, so statute means a written law, whereas law, the term law could mean ordinance, order, bylaw, rule, regulation, notification, and the like. Now let's go to the definition of document. Generally understood, a document is a paper or other material thing giving information, proof, or evidence of anything. The law defines document in a more technical form. Section 3 of the Indian Evidence Act 1872 states that document means any matter expressed or described upon any substance by means of letters, figures, or marks, or by more than one of these means intended to be used, or which may be used for the purpose of recording that matter. So as per the Indian Evidence Act 1872, a document means any matter expressed or described upon any substance by means of letters, figures, or marks, or by more than one of these means intended to be used, or which may be used for the purpose of recording that matter. Alright? Okay, example, a writing is a document. Any words printed, photographs are documents. Okay, so documents means anything which has some writing or inscription or picture on it. Section 318 of the General Clauses Act 1897 states that the term document shall include any matter written, expressed, or described upon any substance by means of letters, figures, or marks, or by more than one of those means which is intended to be used, or which may be used for the purpose of recording this matter. Okay, so this is just a brief description about what you mean by a document. Come on, take a minute, go through this. Any questions, please ask me. Take a minute. Take a minute, please. Go through this carefully. Come on, take another minute. Come on, take another minute. Any questions, please ask me. Okay, can we proceed? Okay, now generally documents comprise of the following four elements. Okay, so normally when we talk about documents, in terms of interpretation of documents, they include the following four elements. Now the elements of documents, first is the matter. This is the first element. Its usage with the word any shows that the definition of document is comprehensive. Okay, so means the definition of document, the word any means it is inclusive. Okay, it is not an exhaustive list, but it's including. So any document or any piece of paper which has these elements can be considered as a document. So the first important element of document is matter. This is the first element. Its usage with the word any shows that the definition of document is comprehensive. Okay, then the second, record. The second element must be certain mutual or mechanical device employed on the substance. It must be by writing, expression, or description. So please remember, a mere plain piece of paper is not enough. There should be something, a mutual or mechanical device employed on the substance. That is paper. It must be by writing, expression, or description, or it could be typed, it could be painted, it could be whatever. Okay, so then it has to be there. A blank piece of paper is not a document. Then you have substance. This is the third element on which a mental or intellectual elements comes to find a permanent form. There should be substance. It should not be gibberish. It should not be gibberish, meaning it should not be rubbish. Whatever is written on that medium or a substance or a paper should make sense. This is the third element on which a mental or intellectual element comes to find a permanent form. So it just like how if you scribble on a paper or something, that exactly does not become a document. Then the fourth one you have is means. This represents fourth element by which such permanent form is acquired, and those can be letters, any figures, marks, symbols which can be used to communicate between two persons. Okay, so there has to be certain means by which a communication is done between two people. The fourth element of documents represents by which such permanent form is acquired, and those can be letters, any figures, marks, symbols which can be used to communicate between two parties. Okay, so that is the important elements of documents. Then let's look at what is an instrument. In common parlance, instrument means a formal legal document which creates or confirms a right or records a fact. It is a formal writing of any kind, such as an agreement, deed, charter, or record drawn up and executed in a technical form. It also means a formal legal document having legal effect, either as creating liability or as affording evidence of it. So Section 214 of the Indian Stamp Act 1899 states that an instrument includes every document by which any right or liability is or purpose to be created, transferred, extended, or extinguished. So now please remember, what do you mean by document and instrument? What is the difference by reading this? The difference between a document and an instrument will be, document means where there is something meaningful written on it. It could create a legal relationship or it could not create a legal relationship. But whereas an instrument is something that is a document that actually is created, transferred, extended, extinguished, or recorded by which a right. So it does create a legal relationship. Okay, that's the basic difference between a document and an instrument. Please take a couple of minutes, go through this. Any questions, please ask me. Any questions, please ask. Please take another minute. Come on. Any questions, please ask. Are we done? Any questions, please ask me. Take another minute, please. Okay, then let's look at what you mean by deed. The legal glossary defines deed as an instrument in writing or other legible representation of words on parchment or paper, purporting to effect some legal disposition. Simply stated, deeds are instrument, though all instruments may not be deeds. Okay. However, in India, no distinction seems to be made between instruments and deeds. Okay. So in India, normally the term instruments and deeds are used interchangeably, and there is no distinction seems to be made between both of them. Then, what do you mean by interpretation? This is the crux of this chapter. By interpretation is meant the process by which the courts seek to ascertain the meaning and line of the legislature through the medium of the authoritative forms in which it is expressed. Simply stated, interpretation is the process by which the real meaning of an act or statute or document and the intention of the legislature in enacting it or of the parties executing the document is ascertained. Interpretation signifies expounding the meaning of abstruse words, writings, making out of their meaning, explaining, understanding them in a specific manner. A person is thereby aided in arguing, contesting, and interpreting the proper significance of a section, a proviso, explanation, or schedule to an act or any document, deed, or instrument. Okay, so simply speaking, interpretation means to give meaning to something, to give meaning as to what was the real essence of introducing or saying something or writing something. Okay, that is what you mean by interpretation. Please take 2 minutes, go through this. Any questions, please ask me. Please take a couple of minutes, go through this. Come on, let me know once you're done, please. Are we done? Any questions? Please ask me. Okay, now let's look at classification of interpretation. Okay, so what are the various classifications of interpretations? First one, legal. Okay, it is legal when there is an actual rule of law which binds the judge to place a certain interpretation of the statute. It is doctrinal when its purpose is to discover real and true meaning of the statute. Legal interpretation is subdivided into authentic and usual. It is authentic when rule of interpretation is derived from the legislator himself. It is usual when it comes from some other source such as custom or case law. Okay, so basically a legal interpretation is when the judge has to place a certain reliance on certain legal interpretation or legal rules. Then it becomes a legal interpretation, and it is normally authentic and usual. Authentic and usual. Then let's look at what is doctrinal interpretation. Interpretation may again be divided into two categories: grammatical and logical. It is grammatical when the court applies only the ordinary rules of speech for finding out the meaning of the words in the statute. On the other hand, when the court goes beyond the words and tries to discover the intention of the statute in some other way, then it is said to resort to what is called as logical interpretation. Okay, so doctrinal simply means now there are two ways in which you can interpret something. Either something which used by simple grammatical words, you try and understand what those words mean, and then you interpret it that way, or the next way is you try to go a little further than that and apply logic to what was actually intended, and then you try to interpret. So doctrinal means that. Okay, in doctrinal you have grammatical as well as a logical interpretation. Okay, please take a couple of minutes, go through this, and then we proceed. Any questions? Please ask me. Come on, take a couple of minutes, go through this. Any questions you may have, please ask me. Let me know once you're done, please. Are we done? Okay, then let's move on. Interpretation and construction. It would also be worthwhile to note at this stage itself the difference between the terms interpretation and construction. While more often than not, the two terms are used interchangeably to denote a process adopted by the courts to ascertain the meaning of a legislative form in which it is expressed, these two terms have a different meaning, okay? Different connotations. So even though we might use these terms interchangeably, interpretation and construction, please remember the courts, while delivering judgment or while interpreting things, use these two terminologies differently. So let's look at the difference between interpretation and construction. Interpretation differs from construction. Interpretation is of finding out the true sense of any form, and the construction is the drawing of conclusion respecting subjects that lie beyond the direct expression of the text. Okay, so interpretation is the finding out the true sense. So if you want to find out the true sense of why something was said or something was written, then you do an interpretation. And construction is the drawing of conclusions. You go a step further and you draw conclusions. Okay, this is being said, maybe means this, or this is what is the objective. Respecting subjects that lie beyond the direct expression of the text. It is the duty of the courts to give effect to the meaning of an act when the meaning can be equitably gathered from the words used. Words of legal import occurring in a statute which have acquired a definite and precise sense need to be understood in that sense. When the legislature uses certain words which have been acquired a definite meaning over a period of time, it must be assumed that those words have been used in the same sense. So basically, of usage as well, custom of usage. So if certain words have been used in a particular way over a period of time, then further while deciding on things as well, you can assume that the words have been used in the same sense. That is what you mean by interpretation and construction. Come on. Please take 2 minutes, go through this. Any questions, please ask me. Come on, any questions you may have, please ask me. Please take a couple of minutes. Come on, any questions, please ask me. Let me know once you're done. Come on, take another minute. Go through this carefully, please. Any questions, please ask me. Carefully go through this, it's an important slide. Are we done? Okay, take about 30 seconds more, then we proceed. Okay, now why do we need? Now let's come to the important question: why do we need interpretation and construction? Okay, no doubt in modern times the enacted laws are drafted by legal experts, yet they are expressed in language, and no language is perfect as to leave no ambiguities. Like I told you, even though every law or statute is prepared by experts in that field, but please remember at the end of it, the law is written in a particular language, and no language is so perfect as to leave ambiguities. Okay, so ambiguities means confusions. So because of these ambiguities that a language provides, there is a need for interpretation and construction. Further, by its very nature, a statute is an edict of the legislature, and many a time the intent of the legislature has to be gathered not only from the language but the surrounding circumstances that prevailed at the time when the particular law was enacted. If any provision of the statute is open to interpretations, the court has to choose that interpretation which represents the true intention of the legislature. Also, it is not within human powers to foresee the manifold set of facts which may arise in the future, and even if it were so, it is not possible to provide for them in terms free from all ambiguity. All these aspects add to give great prominence to the subject of interpretation and construction in practical administration of law. Please remember, see, there are a lot of things that give rise to this need for interpretation and construction. Now, what could be? Now, someone has created the law. First and foremost, he's used language. It could be English, it could be Hindi, it could be Kannada, it could be any languages. And there is no language which is not open to interpretations. Okay, so that is the first need for interpretation. The next need is, please remember that someone else has created the law. So when wrote the law. So when he was writing it, there was something that was going on in his mind, and his intent of creating it might be different from what you're thinking right now. Okay, now in the future what will happen, don't know, but at least in the past when that statute or law was prepared, we need to make the interpretation as close as possible to what that person was thinking who made the law. Okay, and the next thing is, please remember, there were a lot of laws like we did yesterday, Negotiable Instruments Act 1881. It was prepared way back in 1881. Today we are in 2021. It's about 140 years. Okay, so then in that case, the interpretation at that point to now, the situations, the scenarios, the society, everything has changed. And because of that, the need for interpretation could arise even more. Okay, so these are the reasons why the need for interpretation of statute arises. Please take 2 minutes, go through this. Any questions, please ask. Any questions you have, please ask me. Come on. Please take another minute, couple of minutes, go through this. Come on, any questions, please ask me. Go through this. Come on, any questions? Take about 30 seconds more, then we proceed. Okay, now let's look at the rules of interpretation or construction. Over a period, certain rules of interpretation and construction have come to be well recognized. However, these rules are considered as guidelines only and are not inflexible. These rules can be broadly classified as primary rules, that is the rule of literal construction, rule of reasonable construction, rule of harmonious construction, rule of beneficial construction, rule of exceptional construction, and the rule of ejus then generis. Then we have secondary rules, that is the effect of usage, associated words to be understood, alright, in common sense manner. So these are your primary and secondary rules which are normally employed while interpretation of statutes or laws. Okay, we will go through each one of them in detail, but please take a minute, go through them right now and then we proceed. Come on. Are we done? Okay, let's have a look at first of the primary rules, the rule of literal construction. So let's look at how, as per the literal construction, a law or statute is interpreted. Okay, it is a cardinal rule of construction that words, sentences, and phrases of a statute should be read in their ordinary, natural, and grammatical meaning, so that they may have effect in their widest amplitude. At the same time, okay, so first and foremost, it is a cardinal rule of construction or interpretation that whatever language or grammatical sense a particular statute has been written, it should be read in the same way. Okay, and phrases of a statute should be read in their ordinary, natural, and grammatical meaning, so that they have the effect in the widest amplitude. That means if you normally first start to interpret something with their normal meaning, they will have the widest applicability. At the same time, the elementary rule of construction has to be borne in mind that words and phrases of technical nature are prima facie used with their technical meaning, if they have any, and otherwise in their ordinary popular meaning. So please remember, now there are two kinds of things you will read. When you read something, you will read a general stuff, which should be understood in the general and grammatical meaning, and then you will read something technical. So if there is anything technical, they have to be read in the technical meaning. So let's say if there is an engineering student and he says something technical, then that has to be understood in the context of engineering. If a chartered accountant says something technical, that has to be understood in the context of chartered accountancy, and so on and so forth. That is, if they have any technical meaning. If there is no technical meaning, then they also have to be read as per their ordinary popular meaning. Okay? For example, when we talk of disclosure of the nature of concern or interest, financial or otherwise, of a director or manager in the company in the subject matter of a proposed motion, as referred to in section 102 of the Companies Act 2013, we have to interpret it in its broader sense, that any concern or interest containing any information and facts that may enable members to understand the meaning, scope, and implications of the items of business and to take decisions thereon. What is required is a full and frank disclosure without reservation or suppression, as for instance, where a son or daughter or father or mother or brother or sister is concerned in any contract or matter, the shareholders ought fairly to be informed of it and material facts disclosed to them. Here, a restricted, narrow interpretation would defeat the very purpose. So now, see, this is a good example now. as per the Companies Act 2013, if there is any board resolution being passed, and if any of the directors, okay, need to disclose their interest in that resolution. If their interest in the resolution means if someone is really interested in that, that means it could be a resolution involving a firm in which the director's wife is a partner, or the son is a partner, or another company in which the director's wife is a director. So all these things he should disclose. Okay, so in the narrow sense, he can say, okay, I don't have any interest in that, so I will not disclose. But the actual interpretation of that will be if in case the son, daughter, father, mother, brother or sister of the director is concerned in the contract, then that also he has to disclose. So it's always good to take the broader view than the narrow view, because the narrow interpretation would defeat the very purpose of the disclosure. Okay, please take a couple of minutes, go through this. Any questions, please ask. Come on, any questions you have, please ask me. Come on, any questions, please ask me. Take a minute, go through this. We are dealing with the primary rules of interpretation / construction. So we are talking about the first one of rule of literal construction. Alright, any questions you may have, please ask me. Take another minute, go through this carefully. Any questions, please ask. Come on. Any questions, please ask. Any questions? Come on, take another minute, please. Are we done? Okay, words used in the popular sense. Now we are looking at literal construction. The words used in the popular sense. Dealing with matters regarding the general public statute are presumed to use words in their popular sense, but to deal with particular business or transactions, words are presumed to be with a particular meaning in which they are used and understood in the particular business. However, words in statutes are generally construed in their popular meaning and not in their technical meaning. Okay? So, reasonable corrections are not to override plain terms of the statute. A construction that will render ineffective any part of the language of a statute will normally be rejected. Okay, so basically, if there is any such interpretation that comes out that renders ineffective any part of the language or statute, will be rejected because please remember every part in a statute was written for some purpose. If it is there, there has to be a purpose, and the interpretation, the whole idea of interpretation is to find out why it is there. So, if there is any interpretation which gives you a useless meaning of the law, then that interpretation cannot be used. For example, if an act plainly gives the right of appeal from one court of quarter sessions to another, it was held that such a provision, though extraordinary and perhaps an oversight, could not be eliminated. So let's say if any act gave you a right to apply in an appeal in the same court, not in the higher court, in the same level court. So on the plain reading of it, it appears that it was a mistake, but actually if it was given, it was held that it was done for some purpose, and it could be some extraordinary event which would have led to that and cannot be eliminated. Now the different headings for literal construction. What are the different headings for literal construction? Natural and grammatical meaning, explanation, exact meaning leading to loose meaning, technical words in technical sense. Okay, we will go through each of them also in detail. Please take 2 minutes, go through this. Any question, please ask me. Any questions, please ask me. Let me know once you're done, please. Come on. Any questions, please ask me. Come on, take another minute. Any questions? Okay, now let's look at what we mean by natural and grammatical meaning. Remember, we are still with literal construction. Statutes are first to be understood in their natural, ordinary, or popular sense and must be construed according to their plain, literal, and grammatical meaning. If there is an inconsistency with any express intention or declared purpose of the statute, or it involves any absurdity, repugnancy, inconsistency, the grammatical sense must then be modified, extended, or abridged only to avoid such things. So the first rule is, whenever you're interpreting any statute or law, you should interpret it as per its normal and ordinary or popular sense and grammatical meaning. Don't get too technical and don't get too much into it. It's only when after doing this you don't get a proper meaning pertaining to that situation, then the grammatical sense must be modified, extended or abridged only to avoid any such inconvenience, but no further. Okay, example, in a question before a court whether the sale of betel leaves was subject to sales tax, in this matter, Supreme Court held that betel leaves could not be given the dictionary, technical or botanical meaning when the ordinary and natural meaning is clear and unambiguous. Being the word of everyday use, it must be understood that in its popular sense, by which people are conversant with it also, the meaning which the statute dealing with the matter would attribute to it. Therefore, the sale of betel leaves was liable to sales tax. So in this particular example, when the question came before the Supreme Court whether sale of betel leaves is liable to sales tax, the Supreme Court simply said, let's not get into technical terms or anything like that. In normal, popular terms, how is it used, betel leaves? It is used for human consumption, right? So when the natural meaning is clear and unambiguous, let's not get technical, and that is where the Supreme Court held that the sale of betel leaves was liable to sale tax. Okay, please take a couple of minutes, go through this, and then we proceed. Any question? Please ask me. Come on, any questions? Please ask me. Any questions? Please ask. Take another minute. Come on. Any questions? Please ask. Come on. You want to take another minute? Let me know once you're done, please. Come on. Any questions? Okay, then let's look at the next one, explanation of the rule. When it is said that words are to be understood first in their ordinary, natural and popular sense, it is meant that the words must be qualified, that natural, ordinary or popular meaning which they have in relation to the subject matter with reference to which and the context in which they have been used in the statute. The meaning of the word depends upon its text and context. In the construction of statutes, The context means the statute as a whole and other statutes in pari materia, where two enactments have the common purpose. So please, even though we have said in the particular, in this case that they should be used in their ordinary, natural and popular sense, please remember they should be used in their ordinary, natural and popular sense in the context of the statute. Now, what do you mean by context? Now, let's say, let's wait 1 second. Let me think of a word. Okay, I'll tell you that. So whenever you're trying to get the natural, ordinary or popular sense, you should get that popular sense or natural thing of the word in the context of the law. Okay. Example: in constructing the Andhra Pradesh General Sales Tax Rules 1957, the words livestock means all domestic animals will not include chicks, construing in the popular sense, although in literal sense animals refers to any and every animate object as distinct from inanimate object. So in this example, means all domestic animals will not include chicks, constructing. So chicks were not included as livestock, but whereas the other animals were all included as livestock, construing in the popular sense, although in literal sense animal refers to any and every animate object as distinct from inanimate object. So this simply means whenever you are interpreting or constructing something, it has to be done in the context of the respective statute or law. Please take a minute, go through this. Any questions, please ask me. Come on, let me know once you're done, please. Any questions, please ask. Come on, let me know once you're done. Come on, any questions, please ask. Any questions, please ask me. Let me know once you're done. Are we done? Okay, let's move on. Now, let's look at the third one, exact meaning preferred to loose meaning. This is another point regarding the rule of literal construction, that exact meaning is preferred to a loose meaning in an act of parliament, as every word has a secondary meaning too. Therefore, in applying this rule, one should be careful not to mix up the secondary meaning with the loose meaning. Wherever the secondary meaning points to that meaning which statute meant, preference should be given to that secondary meaning as well. Okay, so the rule of literal construction means that you should look at the exact meaning of a word and not rely on its loose meaning, but on a little bit more. So whenever that exact interpretation or meaning of the word gives meaning to the statute, then that should be preferred. Example, the word obtain in general sense means some request or effort to acquire or get something, but in the secondary meaning it is to acquire or get without any qualification, and if in a statute the secondary meaning is preferred, it can be said that the preference has been given to a loose meaning. So what this means is there's no fixed rule actually that you should look at the exact meaning only. Even if the loose meaning or the secondary meaning gives meaning to the statute, you can take that meaning. That is the secondary or the loose meaning. Technical words in technical sense. The point on literal construction is that technical words are understood in the technical sense only. Example, in constructing or construing of the word practice in the Supreme Court Advocates Act 1951, it was observed that practice of law generally involves the exercise of both the functions of acting and pleading on behalf of a litigant party. When legislature confers upon an advocate the right to practice in a court, it is legitimate to understand that expression as authorizing him to appear and plead as well as to act on behalf of suitors in the court. Okay, so this is what you mean about technical words in technical sense. Please take a couple of minutes, go through this. Any questions, please ask. Please take another minute. Any questions, please ask me. Come on, take another minute, go through this. Any questions, please ask me. Come on. Please take another minute. Any questions you have, please ask me. Any questions, please ask. Any questions? Come on, let me know once you're done. Okay, let's move on to the rule of reasonable construction. According to this rule, now what we saw so far was the rule of literal construction. Now let's look at the rule of reasonable construction. According to this rule, the words of a statute must be construed ut res magis velit quam perit, please pardon my pronunciation, meaning thereby that the words of statute must be construed so as to lead to a sensible meaning. So that is what it is based on. So whatever you do in interpretation of the law, it should be done so as to lead to a sensible meaning. Generally, the words or phrases of a statute are to be given their ordinary meaning. A statute must be construed in such a manner so as to make it effective and operative on the principle of ut res magis velit quam perit. So while interpreting the law, two meanings are possible, one making the statute absolutely vague and meaningless and the other leading to certainty and meaningful interpretation. In such case, the latter interpretation should be followed. So whenever you face a situation where one meaning, one interpretation of the statute gives you a rubbish meaning or a vague meaning and one interpretation gives you certainty and meaningful interpretation, the rule of reasonable construction says that you should look at the latter one, that is the interpretation that leads to certainty and a meaningful interpretation. Okay, so that should be followed. Now, an example in the case of Dr. A.L. Mudaliar versus LIC 1963, it was held that the memorandum of association of a company must be read fairly and it is important and its import derived from a reasonable interpretation of the language which it employs. Further, in order to determine whether a transaction is intra-vires the objects of the company, the object clause should be read reasonably construed, neither with rigidity nor with laxity. Okay, please take a couple of minutes, go through this. Any questions, please ask me. Any questions, please ask. Come on. Please take another minute, carefully go through this. Rule of reasonable construction. These are all important questions from the exam point of view as well, so you need to know them. Let me know once you're done. Okay, let me know once you're done, please. Come on. Any questions? Please ask me. Are we done? Come on. Okay, now let's move on to the rule of harmonious construction. So we've seen rule of literal construction, reasonable construction, and let's look at rule of harmonious construction. When there is a doubt about the meaning of the words of the statute, they should be understood in the sense in which they harmonize with the subject of the enactment and the object which the legislature had in view. Their meaning is found not so much in a strictly grammatical or etymological propriety of the language, nor even in its popular use, as in the subject or in the occasion on which they are used and the object to be attained. So in a harmonious construction, we deviate a little from the rule of literal construction and the reasonable construction, where in case you are not able to understand the particular words of a statute, they should be read in terms of the overall object which the legislature had in view, and you should not even go for the grammatical meaning or the popular meaning, okay, whatever it is, but you should go in the context as how it harmonizes with the law in hand, okay. It should not be something that is too contrasting. Now let's look at an example. As per the facts given in Raj Krishna versus Vinod, AIR 1954 SC 202, there was a conflict between section 33.2 and 123.8 of the Representation of People Act 1951. Section 33.2 stated that a government servant may nominate or second, a candidate seeking election, whereas Section 123(8) provided that a government servant is not entitled to assist a candidate in election in any manner except by casting the vote. So you see that Section 33(2) and Section 123(8) were of the same law, same act, that is the Representation of People Act 1951, was in contradiction. So how this was handled by the Supreme Court. Supreme Court observed that both these provisions should be harmoniously interpreted and held that the government servant was entitled to nominate or second a candidate seeking election to the state legislature assembly. This harmony could be achieved only if Section 123(8) of the Act is interpreted as conferring power on a government servant of voting as well as of proposing and seconding a candidature and forbidding him from assisting the candidate in any manner. So, how the Supreme Court tackled it is, Supreme Court said that yes, as per Section 33(2) of the Representation of People Act 1951, a government servant is allowed to assist a candidate in election in any manner. Okay, and he also said that yes, maybe the whole purpose of Section 123(8) was that other than nominating the election of a person to the state legislature and voting, a person cannot help him in any other way. Okay, so that was harmonious construction. Otherwise, there would have been a deadlock between those two sections. Please take a couple of minutes, go through this. Any questions? Please ask me. Come on, any questions? Please ask me. Please take a couple of minutes. Any questions? Please ask me. Carefully go through this. Come on. Any questions? Please ask me. Come on, let me know what's your on, please. Come on, take another minute. Go through this. Any questions? Please ask. Come on. Any questions? Please ask. Come on. Come on. Any questions? Please ask. Okay, now let's look at the fourth rule. The fourth rule of beneficial construction, or the Hayden's rule. So what have we seen here so far? We've seen literal construction, reasonable construction, harmonious construction, and now let's look at this important one, beneficial construction, or the Hayden's rule. Where the language used in a statute is capable of more than one interpretation, the most firmly established rule of construction is the principle laid down in Hayden's case, 1584. The rule which is known as the purposive construction or mischief rule enables the consideration of four matters in construing an act. Okay, now please remember, the rule of beneficial construction is known as the Hayden's rule. It's also known as purposive construction rule or the mischief rule. Okay, so any of these things could be asked to you in the examinations. So you need to be ready. Okay, so you need to be ready with what the Hayden's rule is all about. So the Hayden's rule says that the four matters should be considered in construing an act. What was the matters? What was the law before making the act? So before a particular act came in, what was the law? What was the mischief or defect for which the law did not provide? So that law, what was the law before this law, the law which you are trying to interpret, what was the law before that? And what was the mischief or defect for which that law did not provide? Then what is the remedy that the act has provided? So what is this new law that has come in which is being interpreted? What is the remedy that is being provided? And what is the reason for providing such a remedy? So these four questions you need to ask whenever you are interpreting something as per the rule of beneficial construction or the Hayden's rule. First one is, what was the law before making this new act what you are trying to interpret? What mischief or the defect did that law not provide for? What is the remedy that this new act has provided, and what is the reason for such a remedy? Okay, so these questions you should ask when you are interpreting the new law. Okay. Example: a statute which requires notice of action for anything done are to be construed as including an omission of an act which ought to be done as well as the commission of a wrongful act. Where the statute requires something to be done by a person, it would generally be sufficient compliance if that thing is done by another person on his behalf or by his authority, for it would be presumed that the statute does not intend to prevent the application of the general principle of law. Qui fecit aliem fecit per se. That means he who acts through another is deemed to act in person. This would be so unless there is something in either the language or the object of the statute which shows the personal act alone was interpreted. Okay, so now this is an example which says that you need to go a little step further and try to get the whole objective of the law. What was the law trying to address, which was not there earlier? Okay, please take a couple of minutes, go through this. Any questions? Please ask me. Any questions? Please ask. Please take another minute. Any questions, please ask me. Come on. Any questions, please ask. Let me know once you're done, please. Any questions? Please ask me. Are we done? Okay, let's go to the next one. Rule of exceptional construction. Let's quickly go through these. The rule of exceptional construction stands for the elimination of statutes and the words in a statute will defeat the real objective of the statute or make no sense. It also stands for construction of the words and, or, may, shall, and must. So The rule of exceptional construction is simple, that any words which destroy the whole objective of the law should be removed, and then you should interpret the law. Then you have the rule of ejus and generis. The term ejus and generis means of the same kind of species, where any act enumerates different subjects. General words following specific words are to be construed and understood with reference to the words that precede them. Those general words are to be taken as applying to those of the same kind as the specific words previously mentioned, unless there is something to show that a wider sense was intended. So this is simple. The term ejus and generis means of the same kind. So in case there are general words and then you have a specific words, then you can understand that those general words are used in context of those specific words, unless and until there is enough proof to show you that those general words mean a wider range. The rule of ejus and generis means that where specific words are used and after those specific words some general words are used, the general words would take their color from the specific words used earlier. Okay, so like I told you, please take a couple of minutes, go through this. Any questions, please ask me. Any questions, please ask me. Come on, please take another minute, go through this. Are we done? Come on. Any questions, please ask me. Come on. Please take another minute. Come on. Are we done? Okay, so in case you're done, we will be ending this session with this. Okay, just give me a minute. Thank you so much for being a wonderful audience. It was a pleasure to make this session for you. Please do not forget to use the code Prathik, Prathik, to get an instant discount of 10% when you make a Plus subscription. Please remember this discount of 10% is being reduced to 5% from 1st of March 2021. So in case you have decided or are thinking about getting into the Plus platform of Unacademy but have not done so yet, this is the time for you to do so. Please do use my code Prathik and get an instant discount of 10%. on your Plus subscription until February 28, 2021. From 1st March 2021, it is being reduced to 5%. And also, once again, I'd like to welcome you to Crack CA Exams with us, which is a vertical and channel of Unacademy that caters to the students of CA Foundation and Intermediate in their journey and pursuit of preparation for the CA Foundation and Intermediate examinations by providing top educators, quality content, and overall a great learning experience. Thank you so much for being a wonderful audience. It was a pleasure to take this session for you, and I look forward to taking some more interesting sessions for you in the future. Thank you and all the best for your exam.